Hi, this is Jen Rubin, and this is Jen Rubin's Green Room. So glad you're back. So it's Tuesday as we sit here, and Donald Trump has gone on the warpath, very predictably, against Judge Merchan, the jurors, the justice system, the state of New York, because, of course, Donald Trump can never lose. If he loses, it's rigged. If it loses, it's corrupt. And this is what he does. This is what he did in the 2020 election. This is what he will do if and when he loses in 2024. This is what he'll do after every adverse verdict. Because two things. One, he, of course, is a pathological narcissist who always has to be right. And secondly, this is what authoritarian bullies do. In order to seize power, in order to make sure that institutions bend to their will, they have to first destroy the credibility of them as they exist already. And this is right out of the strongman playbook. When Orban comes to power, when the Polish right-wing government comes to power, when South American dictators come to power, one of the first things they do after locking up journalists is to go after the independent courts. Why? Because that's the biggest impediment to executive power. You have courts out there that prevent them from doing things. And that's a no-no in the authoritarian playbook. So, of course, Trump is going to go after Merchan. He's going to go after jurors. And because he controls a party that is nothing but a bunch of mini-me's, they all echo that. So you now have an entire political party that is attacking the rule of law, that is attacking a judge, that is attacking a jury, that is attacking the concept that a prosecutor can bring a case successfully against a former president of the United States. That is immensely damaging to our justice system, which depends upon, respect for the rule of law and acceptance of outcomes, whether you like them or not. And I think it's another one of these inflection points. Are we going to let someone run for office, potentially gain office, and the office being the chief executive, the guy who is supposed to enforce the laws, when that person has so little regard for the rule of law, when he will not accept outcomes that don't favor him? And that's another one of the gobsmacking, ironies of this election, that you're having to choose between one guy who more or less does his job, who enforces the law, who believes in the rule of law, and one guy who already has shown he's completely unwilling to uphold his oath, that he will not abide by the peaceful transfer of power. He will not abide by court decisions that don't favor him. So if nothing else, the election itself, the whole campaign he is running, is disqualifying to Donald Trump. But of course, a great many people don't see it that way. And he has convinced an entire party that democracy is a sham, these institutions are a sham, and the only way to protect them and prevent the downfall of Western civilization from these hated elites, these foreigners, is to elect him. And that's where we are today. Now, do I think that's going to be successful? I pray it will not. But the fact that it's even possible tells you that we have reached a pretty low point in American democracy. So what else is going on? Well, the president unveiled an executive order on the border that essentially says, if you cross the border illegally, you can't apply for asylum. Now, the obvious problem here is this has been tried before and the courts have struck it down. Not because it's inherently a bad idea or an unfair idea, but because we have immigration laws that don't allow that say the opposite, that say you have a right to claim asylum if you're in here illegally, if you're being deported, if you're being deported through a full proceeding, through an abbreviated proceeding, that you have the right to raise an immunity and a asylum claim, rather. And they have tried this. Donald Trump tried this. The courts rejected it. So why is President Biden doing this? He's doing it to make a point. He began negotiations, if you recall, with then Speaker McCarthy back in the fall when he was balking, McCarthy was, about keeping the government running if we didn't first deal with the border. He continued to negotiate until he got booted out. Then the White House said, okay, we'll go negotiate with the Senate, because at that point, the Senate was refusing to give aid to Israel, to Ukraine, and to Taiwan without a tough border provision. So what did they do? They negotiated a tough border provision. And in fact, it was negotiated by James Lankford, who was a pretty hard right-winger. Donald Trump stood up and said, oh, no, we can't let Donald Trump have a president to run against who has actually fixed a problem. We have to have a problem. So he told them all to vote against it. And like good little marionettes, they voted against it. This came up just a week ago again when Chuck Schumer put this same measure back on the Senate floor. And of course, the Republicans filibustered it. So Biden now goes to the country and says, what do you want me to do? I've tried everything. I'll throw a Hail Mary. I'll throw this possible avenue of securing the border. And the Republicans say, oh, you should have done this earlier. What, when he was negotiating with them? You should have done this through Congress? He's been trying to do it through Congress. So he's making a pretty powerful argument that these guys are hypocrisy personified, that if they want to make the border a top issue, and frankly, it is an issue. I wouldn't say as much of a deal as the Republicans say, but let's grant them that it's an important issue. We want to control our borders. But you can't then at every turn prevent a solution because you want the other guy to look bad. So that's essentially what Biden is saying. And he's making a larger point here too. And that is, you do not want to go back to the agent of chaos. This guy wants things to be a mess. I want to solve problems. He wants the mess. And that's a somewhat powerful argument in a country that really would just like the government to operate with some modicum of sanity and competence. So we'll see what comes of that. I suspect it will be challenged immediately in court. Perhaps it will be struck down. And then Biden this summer will go back to Congress and say, you want to try it again. And we'll see if Republicans during the long, hot summer of Washington, D.C., just months before an election, actually want to filibuster again in solution to our border problem. We'll see. Lastly, the Middle East continues. Last Friday, President Biden did something very interesting. He put out a proposal for an immediate ceasefire and then a permanent ceasefire, a stepped procedure to essentially end the war. He did this for a couple reasons. One, he did it to show the American people, and particularly his critics on the left, I want to solve this problem. You want a ceasefire? I want a ceasefire. I don't know why you guys are continuing to criticize me. I'm doing whatever I possibly can. You think I want the war to go on? Of course I don't want the war to go on. So he's answering some of his domestic critics. He's also forcing the Israelis' hand, and to a large degree, he's gotten away with it, that they have to say, okay, we're ready. This is acceptable to us. We'll take the deal. That yes, Bibi talks about fighting forever. Yes, he talks about having to completely destroy the Hamas contingent in Gaza. But yes, this is generally acceptable to us. Now, some of his coalition partners won't go along with it, but if push came to shove and he supported it, the opposition parties would support it as well. And so what this does, this reminds people, you know what the problem is? It's Hamas. It's the people who murdered 1,200 innocents and took a couple hundred people back to Gaza, who has killed about a third of them and won't give them back. That's the problem. The problem is not President Biden. The problem is not solely, at least, the Israelis. The problem is Hamas. Go protest them. Go tell them that they have a moral obligation to stop the killing. And that's where we return to. It's not a pleasant dilemma for Americans not to have someone convenient to blame, particularly when they want to blame that side all along. But the reality is, this is Hamas's doing, And until there's sufficient pressure on Hamas, sufficient enticement for them to make a deal, probably meaning that the high-level leaders leave with essentially their sidearms, they're going to keep going on. And they're going to keep pushing the Israelis, and the Israelis are going to keep pushing back, and a lot of innocent people are going to be killed. So I don't know that this is a solution to the war, but I think in some respects it was a long overdue recalibration by the White House to say, this war was not a war of our choosing or of Israel's choosing. It's gone on too long. We do have a solution. And now Hamas, what are you going to do about it? And so in that respect, I think it was a pretty effective political and strategic message. Now, I'll end on this. This week is the 80th anniversary of D-Day. And whenever you look at those grainy films or you watch Saving Private Ryan, it does take your breath away. The sheer courage of those men racing through the water, racing up against those hills to be shot at, to be bombed at, to be struck down by the German forces. The courage is simply breathtaking. And they did it. Some of them did it just out of a sense of sheer survival. Some of them did it to save their buddies. Some of them did it because they knew they were facing evil incarnate, and that it was either them or evil, and they were not going to allow evil to reign. But whatever their motivation, they acted with such selfishness, such bravery, such a sense of obligation that it should shame every American who doesn't bother to vote, who doesn't bother to get informed, who checks out of the political process. If those young men could die by the hundreds and the thousands to maintain our democracy, the least we can all do is try to uphold it. The least we can all do is work to prevent it from falling into the 21st century fascists' hands. And that guy is Donald Trump. No one's asking you to storm the beach. No one's asking you to give your life. They're just asking you to get out there and participate in the political process so that those men's sacrifices mean something. Do you have trouble finding the ideal sheet? Well, I have news for you. Finding the right temperature at night is a struggle we all face. But recently, I found a way to sleep in perfect comfort all night long. Whether you sleep too hot or too cold, my secret is using the NASA-inspired silver-infused bed sheets by Miracle Made. Their self-cleaning, antibacterial, eco-friendly bedding prevents 99.7% of bacteria, so they stay fresher 3 times longer. That means 3 times less laundry, too. Thanks to Miracle Made, you'll stop sleeping on bacteria that can clog your pores and lead to breakouts and acne. They even eliminate bad odors, so your bed always feels freshly made. Life is much more comfortable and clean with Miracle. Plus, the temperature-regulating silver-infused fabrics were inspired by NASA to give you maximum comfort. Just picture yourself getting a better sleep every night. Miracle sheets feel soft and luxurious without the high price tag of other luxury brands. They feel even nicer than bed sheets used by some 5-star hotels, so you'll feel like you're on vacation every time you get into bed. I imagine I'm in Tuscany or the Riviera, someplace lovely. Ask yourself, what part of dreamland will Miracle take you to? Miracle has a whole line of comfortable, self-cleaning, eco-friendly bedding, pillowcases, and comforters. I know you'll love them, and with Father's Day coming up, dads will too. So go to trymiracle.com/greenroom to try Miracle Made sheets today. And whether you're buying them for yourself or as a gift for a loved one, if you order today, you can save over 40%. And if you use our promo, Green Room, at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product that it's backed with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/greenroom and use the code GREENROOM to claim your free 3-piece towel set and save over 40%. Again, that's trymiracle.com/greenroom to treat yourself. Thank you, Miracle Made, for sponsoring this episode, and you can look for the link in the show notes. We have had a load of legal news lately, haven't we? So I thought we would bring in someone who is an expert on all things legal. He's a law professor at University of Texas, and he's a very entertaining, informative presence on social media. That's how I got to meet him. And I think he's the perfect person to help break down not only what happened in Trump's conviction for 34 felonies, but also to explain what he's doing to attack it, what the chances are with upholding it, and kind of where we go with the rest of the Trump litigation train. Lee Kovarski, welcome to the show.
Thank you for having me, Jen.
It is such a pleasure. So have you finished grading all those law school exams? Are you free for your summer?
Absolutely not, which is what accounts for my extensive social media activity, because as soon as the opportunity cost of my time is something other than grading exams, I'm going to disappear into a world of productivity.
There you go. There you go. Well, I know it is, in talking to many law professors who I actually spend a lot of time talking to, they all to a person say, the grading the exams is the worst part because you really have to pay attention and it's just tedious one after another.
Oh yeah, I love teaching, right? But people ask about grading exams and I tell them it's like, imagine the most boring article you read all year. It's 50 pages long and you have to read it 110 times really carefully.
Exactly. But I'm sure your students will get your full attention. So we have just had a remarkable historic event. And because we've gotten so inured to Trump and insanity, you really have to appreciate we being the collective we in the rule of law and the judicial system of New York, have convicted a former president of the United States of 34 felony counts. I mean, it's hard to imagine something that is more, I think, illustrative of what we mean by the rule of law. What was your overall impression, first of all, of the decision to bring him to trial in New York, and then kind of the difficulty that both the judge and the jury had in trying to treat this like a normal case, even though obviously the former president of the United States sitting there?
Yeah, I think there are lots of reasonable questions about the exercise of prosecutorial discretion to bring this case. The way American prosecution works and the reason why the scholarly literature often talks about prosecutors as the big bad in American criminal law is because the legislatures effectively delegate enormous discretion to prosecutors by writing really broad, punitive statutes. And then they just say to the prosecutors, go figure out how to enforce it. And so the prosecutors exercise discretion, and there's people that are very trenchant critics of the way that discretion is exercised and what it means for the prosecutors to have that discretion. And I count myself among those people. The reason why there is so much criticism of that prosecutor discretion is because once a prosecutor decides to prosecute a case, it often ties the hands of the other legal institutions that have to travel along with it, which ultimately produces my criticism or my assessment of what's going on in the media right now, is that lots of reasonable criticism about the decision to prosecute is being displaced and turned into kind of crazy, wild-eyed criticism of what the judge and jury did inside the courtroom.
And I think that's an absolutely critical decision. You can say, listen, if I were Alvin Bragg or I were any prosecutor, I would think twice and three times about bringing this kind of indictment against a president of the United States who, after all, is facing legal challenges, if you will, in lots of other venues. But that's different than saying the trial was corrupt, the judge was the devil, the jurors were somehow being manipulated. It seems that the first is part of the normal discourse of the body politic because we, after all, elect prosecutors and we have these arguments in the political space about what cases they bring and what they don't. But the second seems like something very different and pretty pernicious.
Yeah, I totally agree, Jen. I'll say at the outset that there's a lot that we don't know about the decision to undertake the prosecution. Given what I know, if I were a prosecutor, a state of affairs nobody would want, by the way, then I would not have undertaken the prosecution. That being said, I think the argument that this is some intergalactic travesty of a prosecution can be overstated a little bit. Why? Because, like, yeah, sure, it's the first time that this particular charge has been accompanied by what we call an object offense. That's a federal election law crime, and people act like that's because they've prosecuted Trump, and because they've targeted Trump. But it's also because any other defendant in this situation, the case wouldn't have gone to trial. They wouldn't have steadfastly denied like verifiably true things like, there was sex with Stormy Daniels.
Right.
And they would have taken a plea to a lesser offense. And so they would have never seen the inside of the courtroom. So the fact that there's so much lack of precedent for this outcome, and the slow motion train wreck that we're watching is on the shoulders of the defendant himself. But, setting the decision to prosecute aside, Judge Merchan colored completely in between the lines when he, conducted the trial. And in fact, there were several key points on which he gave wins to the Trump defense team. And so I just don't think this idea that the trial was rigged or that it was a witch hunt is going to have much purchase beyond social media and traditional media spaces where, frankly, it is kind of effective.
So let's go back to the point about pleading out. In many of these cases, you start with the underlying misdemeanor, which is not a felony. And then it gets bumped up, as you will, or elevated because there's some other crime, in this case, federal election law, state election law, tax law. But any other defendant could well have said, you know what, it's certainly in my interest just to plead on the misdemeanor. I don't go to jail. I don't have a record. Nothing really, bad happens to me. And this whole thing will go away if I just acknowledge that, yeah, I kind of, didn't color in the lines, to use your phrase, on the corporate books. And that was wrong. I'm sorry for it. But come on, this is ticky-tacky, nonsense. And then he could have gone on with his political attack on Alvin Bragg. But that wasn't possible here because Donald Trump will never admit to anything being wrong. There have been lots and lots and lots of business records falsification cases. And I don't want to give the audience the impression that that's not an important thing, because we have those laws on the books largely because they tend to allow other important crimes like, all kinds of tax fraud, all kinds of other, things. If you don't keep honest books, then a lot of other bad things happen. But with Trump, he, to a large extent, kind of forced the hand of the prosecutor. He said, I'm not admitting to anything. Yeah, sure, I wrote all these checks. Yeah, I characterized a bunch of stuff, but, I'm not going to admit to anything. So Bragg kind of had to proceed at that point. Now, one of the points you made is that Merchan really did give the defense a number of outs. One of them was not locking him up after 10 times of contempt. And the kind of behavior he demonstrated is very unusual in a courtroom. To attack the judge personally, to attack jurors, to attack witnesses. Did Trump, in that regard, get an easier ride than a lot of other defendants would have?
In those respects, certainly. I don't want to hazard a broad assessment of whether, he got better than average treatment overall or less than average treatment overall. But, you have to sort of have your head in the ground to say that there weren't a number of moments at trial where the Donald Trumpness of Donald Trump meant that he was being treated differently than any other defendant would have been treated in those situations. I mean, my goodness, I do death penalty litigation. I can't imagine the hell my clients would have to pay if they were screaming about the judge on the courthouse steps after every day's trial proceedings. The idea that you would violate a gag order 10 times and not go to prison for contempt is crazy.
Yeah.
Donald Trump's team won a fight that they probably shouldn't have won over some of the jury instructions.
Right.
So there's, again, just moment after moment that you can point to and you say, actually, Judge Merchan gave them a win.
Right. Now, the jury, in kind of the larger sense, doesn't have a choice. We can put jury nullification off to the side for a moment when a jury essentially says, this is so unjust or the law is unjust and we're not going to carry this out. But if a jury is charged and is going to do its level best to apply the facts to the law, it was a perfectly reasonable decision that they made to convict. If you had sat on that jury, forgetting for a moment the decision to bring the case, would you have voted to convict?
I mean, I assume so. I wasn't in the courtroom.
Right.
I followed, Anna Bauer and Adam Klasfeld and everybody else who, was doing service to their country by tweeting out what's going in the courtroom in the absence of a recording or a transcript.
Right.
But, the fact that the jury came to this conclusion so fast, the fact that even juror number 2, who reported that his media diet consisted only of news from Truth Social, voted to convict after he had time to eat a ham sandwich.
Right.
Suggests to me, all of that in toto suggests that as a matter of evidence, this case just wasn't close at all.
Right. So now, as we have seen, not only Trump, but all of his red-tied, blue-suited, white-shirted little mini-me's have taken to making these crackpot claims that somehow Biden directed this, that the judge was corrupt, that the jury was corrupt. Aside from being ridiculous and annoying, explain why this is actually a really bad thing and a danger when we're trying to wrestle the rule of law into a semi-permanent fixture in American society.
So, in order for all of our institutions to function, they have to be backstopped by a law. You have to respect this thing that this institution does, even if you don't like the way that it does it or the outcome that your interaction with the institution produces. Now, that formula only works if you think that the law is credible enough. The word you'll sometimes hear is legitimate. And if you don't think that the law is legitimate, then you stop interacting with the institutions in a way that reflects confidence. And it's the accumulation of those sort of degraded interactions with institutions that we refer to when we talk about the breakdown in the rule of law. People just don't pay attention to authoritative statements of the rules, and they can't rely on other people to abide by them. It's every person for themselves. And so when you hystericize the uh, what went on in the courtroom, when you engage in profoundly underinformed editorializing about the law that was applied and the law that should have been applied, then you're contributing to that social breakdown. And so talking about this case as though, every little thing that happened was the wildest deviation from institutional norms is either deeply uninformed or deeply dishonest or know-nothing demagoguery.
Now, the other kind of picture that we have, the other frame that we have, is this is going on at a time where a guy is running for the presidency, seeking to essentially dismantle a lot of democratic norms in general. And one of those democratic norms is the independent judicial system that authoritarians normally, if you look at Poland, if you look at Hungary, who do they go after first, aside from journalists? They go after courts, because courts are a break, a stop on executive power. And what we are seeing, I think, is the notion that is being adopted because of Trump and because of his followers, that there is something fundamentally wrong with a legal system in which I don't win, in which my side doesn't get what I want. That seems to be part of a bigger problem with the law and the credibility that we have in institutions. What's the right response when that happens?
I think the response is for those of us that are part of the legal profession to continue to do our jobs, for those of us that are lawyers to abide by legal norms, for judges to enforce those norms, for example, by holding lawyers that file false pleadings and documents accountable the way they have been accountable. The problem is that the system also requires a lot of self-policing. And I think self-policing worked pretty well in electorates of days past. But in a society that's highly polarized, where you can pick a reference group that is just going to cheer you when you do anything that helps your team, it corrodes the norms that work to reaffirm the rule of law.
I also want to make an observation, which, as you say, you may find either ironic or tragic, since you do death penalty litigation, that the crowd that is so determined to maintain the death penalty and wants to seemingly execute as many people as possible has suddenly decided that the judicial system is flawed, that there may be excesses. The most virulent anti-criminal defense justice on the Supreme Court, Justice Alito, now agonizes that there may be prosecutors who are out of control and may seek to indict a former president or a current president. Can you kind of express the sheer hypocrisy, the sheer amazement of this recognition in a justice system in which we really do have inequality? We do have terrible injustices. This is just like hypocrisy in a prom dress, isn't it?
Yeah, I love that turn of phrase. There's a lot of defense side people like myself who are intimately familiar with the way the criminal legal system preys on structural disadvantage, the arbitrariness nested under every moment of decision making, and to make the case for reform over the course of a lifetime, and then to watch a set of people who have never shown the slightest interest in the misfiring of the justice system to now take someone like Donald Trump and make that person a flag bearer of structural injustice I don't want to say it boggles the mind, because like that is just the most Trumpian outcome of the 21st century, and of course it works that way. But of
Right.
course, it's extremely frustrating. It's not frustrating on like an intellectual level, because the answer is simple. It's that those people don't actually care about criminal justice at all. They care about Donald Trump and their team. It's not a principled thing, but it does lead to some curious reactions. And you said something interesting on Twitter the other day. Maybe it was yesterday. Maybe it was 10 minutes ago. Twitter time in my brain is.
Yes, exactly. It's like dog years. It goes
But,
on forever.
it was that the respect the verdict credo or mantra is sort of weird. We don't have to respect the verdict in the sense that we have to uncritically accept it in every social endeavor that we undertake in the course of our day. You can criticize it, you can scream about it, you can appeal it. But what we should be able to agree on is that you don't dox the jurors.
Yes, exactly.
You don't go after the family members of the judge. You abide by the legal norms of like appealing stuff. And just like frenzied energy that goes into laying waste to anything that might represent the slightest barrier to Donald Trump's electoral success is a little scary.
Yeah. And I think the judges are the other part of it. This is the crowd who can never find any flag waving judge, any conflicted judge, any judge who does absolute, murder to either the plain text of the Constitution or the last, 150 years of jurisprudence. They admonish us, they condemn any of us who would dare raise those questions. And yet they have invented some parallel universe in which Judge Merchan is, as Trump would say, the devil, and without any facts. So I'm very sympathetic to those judges, some of whom have been saying this for a long time, is we can't really defend ourselves because then we get to be unjudgy. And it then really does depend upon the rest of the legal system to say, whoa, this isn't right. This isn't fair. This isn't productive.
Yeah, in a universe of bad legal arguments, the idea that the verdict is going to get overturned because of some sort of judicial bias is the worst. It'd be good if your listeners understood exactly what this allegation of judicial bias is. In 2020, Judge Merchan spent $35 at a Democrat affiliated website called Act Blue, 15 of which went to Joe Biden's campaign and $20 went to somewhere else. We don't know the details because it's confidential, but based on the price, it sounds like he bought a t-shirt. It's not clear if he even knew the way that money was being divided up. And along with like several dozen other judges, his conduct was reviewed and he got a caution. And the court said, the Bar Association or the ethics panel or whatever it was said that, well, look, given the context and the trivial amount involved here, there's no appearance of bias. And then, Trump moves to recuse. Judge Merchan submits again this question to himself, submits the question to the ethics panel, right? And that's when the ethics panel publicly goes on the record and says again, it is no reasonable person could believe there's an appearance of bias here. So, this idea that Judge Merchan is hugely biased because he bought what seems to be a t-shirt, some fractional percentage of which was funneled to Joe Biden's campaign is just crazy.
It wasn't like he flew a flag upside down over his house,
No, it's not.
So the latest insanity, and by the way, is sort of like that Seinfeld episode of Bizarro World. If you ever want to learn what the legal world and the legal norms are, then just listen to the sort of Trump crazies and think the opposite, and you'll get there. What about this notion that somehow the Supreme Court of the United States is going to intervene and save Trump's bacon. Can you explain in what kind of legal universe that might be possible?
A legal universe that is not ours.
Yes.
So it's hard to pin down the provenance of this particular article, but this particular idea, as far as I can tell, the radio host Mark Levin had some conversation with someone who had been a clerk on the Supreme Court, Arthur Ferguson, who was talking about how you can get the Supreme Court involved using something called the All Writs Act, which is sort of like this exotic jurisdiction the Supreme Court has, because this person worked on 6 of these things back like however long ago when they were a Supreme Court clerk. The person was actually confused. They weren't working on original habeas petitions, which was the vehicle by which this thing would actually come up if the Supreme Court were to take it. But the Supreme Court hasn't issued an original habeas petition and relieved state court custody since 1925. And even when it did that, it can only do so after a state prisoner has exhausted all of their state remedies. Donald Trump hasn't even undertaken his appeals yet. And even if state remedies were exhausted, it could only exercise that form of jurisdiction if its traditional, what's called certiorari jurisdiction, weren't intact. So there's like 3 or 4 layers of absurdity to this claim. It's not well developed. It sort of sits in the fever swamps of the right-wing websites, and it's sort of like migrating over to like right-adjacent academic commentary among folks who don't really understand the way Supreme Court jurisdiction works.
Now, this is what part of their complaint was in the first place, so this doesn't quite make sense, but this was a state prosecution under state law. So the only way it would get to the Supreme Court would be after all of these processes, would be some monumental issue of federal constitutional law that everyone has missed from the beginning, including federal court judges who rejected a motion for removal, including everyone else who's kind of looked at this case. Is there any basis for thinking that there's some grave constitutional infirmity here?
I don't want to say that there's a grave constitutional infirmity. I will say that, and I'm using the word norms a lot in this broadcast, but like any other profession, judges have occupational norms. And they sort of look at the law as written and they follow that law. And if we lived in a universe where you just kind of followed the law as written, then based on the Supreme Court decisions that are out there and based on the New York appellate decisions that Judge Merchan was reading, no, there's not really a strong federal appellate issue here. But the Supreme Court overrules its precedent. And it's especially likely to barrel through to new ground in highly salient political cases. And so I wouldn't want to say that there's no chance the Supreme Court gets involved on a constitutional issue because it may want to write some new law. And specifically, I think it may want to say something about the relationship of the prosecution to federal campaign finance law.
Interesting. So because this Supreme Court is so partisan and so attentive to the political needs of Donald Trump, it's not impossible to imagine. It's kind of what you're saying.
Right. It's not impossible to imagine that they would take the case via a pretty normal channel, right. But it is impossible to imagine the fever swamp scenario where there's this quote unquote original writ of habeas corpus used to grab the case from Judge Merchan before it's gone through New York appellate courts.
Right. Now, we don't know what Judge Merchan is going to do on sentencing. People have said, well, he's a first-time offender. It's not a violent crime. He, has been engaged, I guess the most charitable way is in public service in the past. But on the other hand, I made that argument pretty strongly today. He is engaged in this wholesale attack on the judicial system. What is the court to do? We looked at the record during the contempt proceedings. Fine after fine didn't do anything. Is there an argument to be made that not only because of his crappy conduct during the trial, but because of his wholesale, entirely inappropriate attack on the court system as a whole, that might tip the judge in favor of some kind of incarceration?
So I'm going to answer this question as like a prediction, and then I'm going to offer some moral editorializing at the end.
Perfect.
So as a prediction, and I think this is a vice in a lot of folks that are covering this trial, I just want to say we don't know. You've identified things on both sides of the equation, right? On the one hand, he's a first-time offender. He's not a violent offender. And for a Class C felony, it would be very unusual for a defendant to get jail time. On the other hand, he's convicted of 34 of those Class C felonies. And he's engaged wantonly in a pattern of disobedience of the gag order. And courts tend to really care about showings of remorse. And he's utterly remorseless. And so I honestly don't know how all of that cashes out. Morally, I'm stuck because as a general principle, I'm anti-carceral. I don't like the idea that folks go to jail unnecessarily. But it would really bother me to see a Trump exception whereby a totally remorseless defender, just because he's Donald Trump, is the one person who isn't held accountable for that remorselessness or the flagrant disobedience of a gag order. So I really am, I both don't know how to predict it and am pretty deeply conflicted morally about what should happen.
There has been a lot of criticism, some of it justified, some of it not, that Trump was tried in a state court on a state grounds. On the other hand, we've seen what appears to be a little bit of a breakdown in our federal court system, because you have a judge sitting there in Florida who seems bent on deciding nothing or coming up with oddball theories to create a lot of work for the parties and not even bothering to have a pretense of moving the case along. And you have the Supreme Court, which could have denied the appeal from the appellate court, could have taken it earlier, could have not made the parties go back down to the DC court, who took its sweet time and still has not issued an order on the immunity issue. And it does seem like the federal courts are not exactly working with due diligence to move ahead on his criminal federal claims.
So I would pull those apart a little bit. I think Judge Cannon in Florida is both deeply biased and also in well over her head.
Yes.
And I think that, that doesn't warrant much further discussion. And I think your characterization there is totally appropriate. I think what the Supreme Court is doing is a little bit more complicated. Because, yes, it's true that they didn't go as fast as everybody wanted, but they also went much faster than they needed to. And I'm pretty certain coming out of oral argument, not 100% certain, but pretty confident that Trump's going to lose that case. And he's going to lose it pretty badly. Maybe not pretty badly in terms of the vote count, but the median voter who's going to dictate what the holding of the court is going to be pretty far from what Donald Trump hoped to get out of that litigation. So the legal world and the intrigue around the Supreme Court circulates in ways that are impossible to verify. So don't put any stock in what I'm about to say. But the scuttlebutt is that the decision to hear the case wasn't close. Like all of the progressive or the libs or whatever you want to call them, the de-appointed justices were on board too. And certainly everybody else's motivation might have been different, but one could understand Supreme Court justices thinking to themselves, I'm not trying to protect Donald Trump, but of course we're going to be the ones to decide this case now. And again, I'm not weighing in on whether that's right or wrong. I'm just saying, like, I imagine there's at least a couple of justices for whom that's the animating consideration, and that animating consideration is a little bit different than like save Trump's bacon.
And that kind of goes under the heading of a lot of cases in which the court says, well, what are we here for if not for deciding cases like this? You know, why have a Supreme Court if they're not going to decide if a former president of the United States is immune from prosecution? It is of such a magnitude and importance that you do kind of have to hear from the court. Now, they could have heard it before the DC Circuit. They could have heard it more quickly and decided it more quickly along the timelines of the 14th Amendment case. But you don't really begrudge them taking the case. Now, there seemed to be an obvious split during the oral argument. And everything you say about court intrigue absolutely applies to oral argument. You can sometimes get very much bedazzled and confused and misdirected by questions. But at least to the average listener, or the average semi-informed listener, you had a number of justices who think that the DC Circuit got it wrong, that they went too far in perhaps saying you could never have a immunity situation. But we aren't certain how to draw the line, where to draw the line. And in particular, you did seem to have Justice Amy Coney Barrett, who I think is more independent-minded than some of the other justices, say, well, maybe none of this concerns any kind of official acts. And she read a list of allegations to the defense counsel, who kind of hedged, but kind of said, yeah, this is all about, campaign stuff, not about governing stuff. So the court could decide, okay, in theory, there is immunity, but this is just so far beyond any kind of official duties because he was acting as his own, campaign guy, that we're not going to consider it. Or you could get something very messy and very confused that has to go back down for a lot of further inquiry. How do you see that teasing out? And do you have any sense where the Chief Justice might be, who could very well want to write the opinion and be, obviously, the deciding vote?
So I will say that I wrote something saying that, look, the court's already taken the case. It should decide a presidential immunity rule, not just for this case, but for future presidents. Why? Because we're obviously facing the prospect of retributive prosecutions of ex-presidents. It's not just in the mail, it's being promised on every network. And I see it roughly the way you do. Amy Coney Barrett and the chief seemed very skeptical at oral argument of the position that the Trump team was taking. And specifically with respect to the chief, he really only asked two questions of Trump's lawyer. Both reflected an extreme displeasure with the standard that the Trump team had articulated as a possibility for presidential immunity. And it was official acts immunity. The idea that if the president undertakes some conduct in his official capacity, then any criminal prosecution based on that official act is necessarily barred. And so I just don't think, and it's not clear that Trump would even win under that standard.
Right.
So, the chief's position appears to be at least 2 degrees removed from what Donald Trump needs to win, right? 1 degree is even on the broadest standard, he doesn't seem to think that Trump would win. And secondly, he doesn't seem to be enamored with the broadest standard at all. And, if the greater includes the lesser, it actually sounded at oral argument, to me at least, like Amy Coney Barrett was closer to the 3 Democratic appointed justices than she was even to Justice Roberts. She seemed to the left of him.
Yes. Now, there are a couple possibilities just in how this is handled. Let's say, for sake of argument, that they don't accept the argument that anything a president does in his official capacity is immune. And they could say, it's not, here's the rule, go apply it, Judge Chutkan. They could say, well, here's the rule, and Trump clearly isn't covered by whatever definition we come up with. Or they could come up with some kind of halfway in between where they sort of give a list of factors and they still throw it back to Judge Chutkan. What do you think they're going to do? And what would be, I don't want to say the best way, but the most legally efficacious way if we want to solve this issue, not only in terms of this case, as you say, but in terms of potential retributive justice, a year from now or 2 years from now?
So I just want to say before I launch into the answer to your question, I appreciate the extremely menschy way in which you reminded me I hadn't answered the second half of your last question, and I'll just plead my third cup of coffee.
There you go.
So, yes, the Supreme Court could say, here's our definition or standard presidential immunity, and Trump doesn't meet it. And then the prosecution just goes forward. And I've seen a lot of people say, well, if they don't say that, if it requires further proceedings, then the prosecution is just going to be delayed past the election. I don't really think that's quite right either. If it requires further proceedings, but those further proceedings don't require an interlocutory appeal, then I actually think that, the timeline for the prosecution is such that it at least probably starts before the election. I think it's only the case that the prosecution is deferred past the election if they not only say there has to be some additional finding by lower courts, but also that Judge Chutkan's finding is appealable in the middle of the prosecution. In that scenario, I think people who want to see resolution on this case are going to be very disappointed. That being said, I don't know what, in terms of setting up a rule for future presidencies, I'm quite confident that the court is going to articulate that rule in the decision that we're going to get in the end of June. And the forward-facing rule isn't going to be dependent on any subsequent resolution of the specific Trump case in the lower courts.
How do you think the court is going to come out there? Are they going to make it real easy for Judge Chutkan and say, here's the rule, here's what you do? Or are they disinclined to, and remember, we're just at the pleading stage of this case. So really, they're going on the indictment, not on any evidence that's been, provided. Do you think they're just going to send it back and tell her to apply the rules and it'll just kind of percolate through the system? Or you think they're going to try to be a little bit more definitive about this, either because of the need to be definitive or because Trump's conduct is just so far from the line that they're prepared to draw that it would be obviously dilatory not to kind of just come out and say it?
If anything, I think it would be the second one. In other words, I don't think this court is going to rush because they're telling themselves, okay, we need this prosecution to be wrapped up before the election. If that was a priority that was going to dominate other considerations, then the court would have behaved differently when it was granting certiorari. That being said, it is hard to overstate how absurd Trump's presidential immunity arguments are. And so the question is just, Amy Coney Barrett and Chief Justice Roberts, gonna send the case back down for further proceedings when those proceedings are fait accompli under whatever substantive standard they want to declare. I don't think so. I'm not super confident in that. I just think the cone of uncertainty here is pretty wide. But if you force me to bet, my bet would be that it goes back down for further proceedings. But it's not structured such that Trump's going to be able to short circuit the whole thing through another intermediate appeal.
Well, that would be a nice optimistic outcome. I think I would take that kind of resolution.
Nobody would call me an optimist, but
yeah, I know. That's why I'll take it. Yeah, that's why I take one. And what about that case in Florida? You're a prosecutor, say, and you're in a courtroom in which the judge is literally just trying to freeze you in your steps. What can you do? What should you do? And should Jack Smith have done something before the present sense? And by the way, in contrast to the Alvin Bragg case, this is a case in which, of course, you had to bring the case because we're talking about behavior that is so objectionable, that is necessary to enforce national security, and that is routinely enforced in just this way against very low-level people, that it would have been absurd not to have brought the case. So you're the prosecutor, you're compelled to bring it for those reasons, and yet you got this judge who is like literally gumming up the works. What do you do?
So I'll take those questions. I'll take the middle part of the question first, and then the two bookends. And just in terms of the decision about where to bring it, at the time that Jack Smith is deciding where to bring this case, there's a pending Supreme Court case that would have made that the outcome of which could have made it very difficult to establish what's called venue in DC. Plus, if they file in DC, the idea was it would imply that the conduct at issue took place in DC, which means that the presidential immunity stuff could have kicked in.
Right.
Whereas if you file suit in Florida over what happened in Florida, you're necessarily talking about conduct after he was the president. So there's a significant increment of risk that Jack Smith avoided by filing in Florida. But he also assumed some risk. And the risk that he assumed is that when he filed there, it would be assigned to Judge Cannon.
A real judge instead of Eileen Cannon. Yes.
Well, no, the downside risk that was going to be assigned to Judge Cannon. Now, I will say, I'm about as good at thinking like a prosecutor as I am at thinking like an astronaut. That being said, I am pretty familiar with being disliked by the judges that I practice in front of. Not to put too fine a point on it, but I'm a defense side death penalty attorney in Texas. And
boy, are you a glutton for punishment?
Honestly, prioritizing loss avoidance is a piece of an agenda that really needs to be more salient than it is.
Yes.
Okay. A conversation for another day. Point being that, he's looking at a judge. He knows he's probably going to lose in her court. And there's a real risk that based on her behavior, what she does is that she finds a way to dismiss the case after the jury is sworn, but before a verdict. Which would make it effectively unreviewable on appeal, and double jeopardy would mean he could never be tried again. There's no way Jack Smith and his lieutenants don't see that as the most likely outcome, or at least a substantially likely outcome. And so I think right now they're sort of thinking through what their options are. And perhaps how to make a record that will allow them to avoid a double jeopardy problem, or that might, personally, I think they're probably thinking about a recusal motion all of the time.
Yeah.
I think if you know that you're going to lose with near certainty in front of a specific judge, then all of a sudden, what feel like really low probability strategies become more attractive. And seeking recusal is a really, really low probability strategy. But at some point, is it higher probability than the alternative? And just the question is like, when is that inflection point?
Well, low probability claims probably is in your bailiwick because you do try death penalty cases in Texas. And in the not too distant future, I would love to have you on to talk about the death penalty, because I will say this is an issue in which I have changed my mind. That I think getting a better look at the justice system as a whole makes it much harder, I think, for honest people to support a death penalty in the justice system that we have here on planet Earth, as opposed to some idealized one. So I would love to have that conversation with you. We will have you back because that's at least a complete conversation on its own. But in the meantime, thank you so much, Lee, for coming on. It's so lovely to get to talk to you directly and have this fun kind of nerdy conversation. And I will look forward to social media and further conversations.
All right, Jen, thank you so much. And I'd love to come back.
And that was Lee Kovarski. He is one bright fellow. And I think what I take away from that conversation is that this is not a Bragg conviction. This is not a Biden conviction, of course. This is not a Judge Merchan conviction. This is a conviction by his peers, by New Yorkers, by ordinary people that he helped put on that jury. Remember, he could have dinged these people. He could have moved to eliminate some of them if he thought that they were not going to be receptive to his message. But in fact, he dug his own grave. Not only did he dig his own grave by committing crimes, but he insisted on meddling and looking over the shoulder of his attorneys. So he presented a case that was much worse than a lot of lawyers think he might have. Now, from here on out, we know the sequence of events, although we don't know the outcome. He's going to get sentenced on July 11, just a few days before the Republican nomination at the convention, which I think is perfect because I think these people should have the experience of nominating someone who is a freshly sentenced, convicted felon. That's who they back. That's who they don't want to run away from. So they're going to get him. Now, Trump isn't going to jail anytime soon. He's going to be running around continuing to defame the jurors, the judge, the entire judicial system. But at some point, those are going to run out. And unless he becomes president, he's going to suffer whatever penalty Judge Merchan gives him. I certainly hope, I think it's justified to give him jail time. I think that's the only way to teach him a lesson. That's the only way, frankly, to protect jurors, the judge, the entire legal system from his constant harassment and incitement. But whatever the penalty is, the rule of law held in this case. And if we can ever get the darn Supreme Court to work its obligations and get rid of whatever roadblocks the flag-flying Sam Alito and the husband of Jenny Thomas are putting up in the way of a ruling on immunity, then justice can be done in that case as well. So I think this is a perfect example that when the legal system is finally free to do its work, it works. It's not perfect. He may have gotten more justice than he deserved. He may have gotten easier treatment than a lot of blue-collar criminals and a lot of people of color. But in fact, he was convicted. And that's something we should all celebrate. So if you enjoyed this program, please tell your friends. They can listen and follow on YouTube, Spotify, Apple Podcasts, or wherever they get their podcasts. Bye-bye.